Hello everybody, I'm Seth Weissman and welcome to another episode of Safe Real Estate. Today we are going to talk about who can object to a proposed disbursement of earnest money. When the holder holds earnest money and there is a dispute, the holder has the right to disperse the earnest money based on a reasonable interpretation of the contract. And the holder can either give the earnest money to the buyer or to the seller. But the holder must send out a 10-day letter stating what their proposed disbursement is and giving all parties a right to object and to provide the holder with information that may affect what the holder ultimately does with that earnest money. It used to be that when the holder sent out that 10-day letter, it could only be objected to by the buyer or the seller. That provision has now been rewritten so that any party or person who has an interest in the dispute can send a letter of objection. And what that does mean is that the real estate brokers involved in the transaction can now object on behalf of their customers and their clients. I think that's a very good change because it really allows for more information to be brought to the table so that the holder can decide what then should I do with the money. And in some occasions, the holder will receive sufficient information where they change their mind about the disbursement. And in that case, the holder must then send out a second 10-day letter that basically goes through the process again and says, I've changed my mind. I'm now going to be giving the money to this party, and again, inviting objections. So in conclusion, anyone can now object to the proposed disbursement of earnest money so long as they have an interest in the dispute. I hope this episode of Safe Real Estate has been beneficial. As always, it's great to see everyone. Please continue to tune in. Bye now.